Welcome back, ladies and gentlemen. I hope all of you enjoyed your lunch. Moving on, we have the second session of the colloquium, which is a substantial part that affects us as media, titled Safeguarding the Indian Democracy. This session will be chaired by Mr. Sashi Kumar, the chairperson, Asian College of Journalism. There are two key speakers and two themes in this session. The first theme, freedom of expression and its discontents, will be presented by Dr. Anushka Singh. I invite Habiba Nazneen to honor Dr. Anushka Singh on our behalf. Dr. Anushka Singh is an assistant professor and deputy dean at the School of Law, Governance and Citizenship, Ambedkar University, Delhi. By training as a political scientist, she graduated from Miranda House and did her master's from LSR, University of Delhi. She was awarded a PhD degree in 2016 for her thesis, Sedition and Democracy, a Comparative Study of Liberal Democracies, from the Department of Political Science, University of Delhi. Before joining AUD, she taught political science at Gargi College, University of Delhi. She has previously also taught at the Lady Shri Ram College and Department of Political Science, University of Delhi. Her areas of interest include nature of state, constitutionalism, law and politics, people's movements, and democratic rights. She was awarded the Visiting Fellowship for Doctoral Research at Tagore Center for Global Thought, King's College, University of London, England in 2014. She was also awarded the ICSSR Doctoral Fellowship in 2015 and ICSSR Doctoral Fellowship in 2014. She is the author of Sedition in Liberal Democracies, published by OUP in 2018. The second theme, namely, future-proofing the Constitution, will be presented by Mr. Kaliswaram Raj, whose book, of course, was released today. Mr. Kaliswaram Raj is a lawyer who practices in the field of civil, criminal, and constitutional law in the Cochin High Court and the Supreme Court. There are over 500 reported judgments in which he is the counsel on record. Among the cases he took up was Joseph Shine versus Union of India, in which he successfully argued for decriminalization of adultery in India. The Supreme Court struck down Section 497 of the IPC as unconstitutional. He has taken up many cases which are public causes and has also been appointed amicus curiae in various cases. He is a prolific writer whose articles appear in various newspapers and periodicals, apart from law journals. His published works in English include The Spirit of Law in 2012, Rethinking Judicial Reforms, Reflections on Indian Legal System in 2017, and now Constitutional Concerns, Writings on Law and Life, published by Tulika Books. There are two discussants for the session. The first discussant is Ms. Geeta Ramaseshan, lawyer and adjunct faculty at our college. I request Habiba Nazneen to kindly welcome her from our behalf.
What about you? Oh, we already said
Yes.
We already knew about that. Yes, yes. Mani Sama. I forgot.
The second discussant, Mr. Vikas Pathak, is a faculty of the Asian College of Journalism.
Where is he? I was wondering why one person is missing. Yeah.
I request Anish to welcome him on our behalf. Now, Mr. Sashi Kumar, the chairperson, Asian College of Journalism, will take the session ahead.
Thank you. So in this session, as was mentioned, the
theme, Safeguarding India's Democracy, and that there are two particular sub-themes, and the first sub-theme which will be addressed first is on freedom of expression and its discontents, which Dr. Anushka Singh will speak to. And in her own description of the outline of what she's going to address, I'm quoting from what she sent us. One of the biggest challenges to the freedom of expression and democracy is the question of line drawing, which determines the threshold of the exercise of the rights of free speech. How can such line drawing be formulated so that it upholds the spirit of constitutional democracy? So that's what she'll be speaking to. And after that, we'll have Dr. COLLOQUIUM Raj speaking about the other sub-theme. And then together we'll open it up for discussion. After the two discussants. We were supposed to have three discussants. Ms. Vaigai, who's a senior counsel, hasn't been able to make it because she had a bad fall and she's kind of, her ankle, twisted her ankle. I just got a message some time back, so she's unable to move. Otherwise, she was looking forward to being here. So we'll have the two discussants, as was mentioned, will be Geeta Ramaseshan, who is a senior lawyer in the Madras High Court, and for us, more importantly, she runs the very important Media Law and Society module at the ACJ, and she's been doing this for several years, and which is what I think makes a big difference to the legal sensitivity and legal exposure that students of journalism at the college get. And Vikas Pathak, as was announced, will be the other discussant. More about him as we draw closer to that. I now invite Dr. Anushka Singh to make her presentation.
Thank you, Mr. Kumar, for inviting me here, and a big thank you to all the organizers. I'm feeling very humbled at a very, very august gathering, and I want to begin with a disclaimer that I'm not trained as a lawyer. So in my talk, my entry point to the issue on the freedom of speech and expression is going to be slightly different. I'm going to enter the theme from the standpoint of philosophy and linguistics, but we'll try and come back to the questions of technical law and try and see how the intersection between the technicalities of law and jurisprudence and linguistics can help us understand a very, very complicated area of freedom of speech and expression a little better, and if not better, slightly differently. So the session is about taking an alternate viewpoint on the issue of freedom of speech and expression. I don't have a paper because a lot of things that I'm going to say are tentative proposals, and I wanted to present something on which one could invite responses from very, very seasoned minds here as well as young minds. But what I have by way of a talk is a framework. I have 3 questions to offer to you. I'm going to first spell out the questions, and then we'll go serially into the questions. The first is this. If we are to assume that freedom of speech and expression entails certain repercussions, not consequences, but repercussions, which means that the right to free speech also entails certain harms. If we are to assume that, and we try and enter the idea of right to free speech, not by way of a right, but through the question of harm, how do we arrive at a theory of free speech? Why am I beginning towards the end? Why am I beginning backwards? It's the norm and exception relationship. Norm is what we ordinarily live in. Exception is what we encounter by way of a crisis. But how do we know that we reside in norm? Only when we encounter something like an exception. So a crisis is what helps us understand the routine better. So what I'm trying to propose here is that restriction on free speech helps us understand what free speech means as a right to us better. Hence, working towards a theory of freedom of speech and expression backwards. That's the first thing. The second thing, which is largely going to be the talk about, is can jurisprudence benefit from insights from philosophy and linguistic theory in terms of devising the structure of the right to free speech in India. And in talking about this particular aspect of my talk, I'm going to draw on something called the performative utterances. If you're not familiar with it, don't worry. We'll try and begin with the basics. I'm working with the idea of performative utterances as propounded by a philosopher of language called J.L. Austin in his book, a very, very interesting book called How to Do Things with Words, since a lot of what we are going to be dealing with in this session is about speech, words. Let's try and see how to do things with words. And then the third and the final aspect of the talk, which is going to be about can the same legal standards be applied to evaluate all kinds of speech crimes. So, you know, even commonsensically and just by being aware citizens, we know that there are a range of speech offenses from sedition to treason to hate speech to pornography to defamation to libel. Can the same legal standard be applied across a range of speech offenses? So that's what the talk more or less entails. Now, to begin with, like I said, we are trying to enter the question of freedom of speech and expression through the notion of harm. How do we know that speech is harmful? We know it right from our Constitution, Article 19, Clause 2, which talks about reasonable restrictions. Why do we have restrictions on free speech? Because of the assumption that if speech is given to you as an absolute right, it's going to have repercussions in the society which may end up harming certain sections of the society, which is why freedom of speech and expression is limited. So restriction, Arun Thiruvengadam is a constitutional scholar, a very well-known one. He's done a fantastic work on the debate on free speech in the Constituent Assembly, and he has a theory. He says that when we began articulating the demand for free speech as part of the Indian national movement, we drew from the universalistic defenses of free speech. So J.S. Mill, his idea of speech resulting in truth being discovered in the society, Thomas Scanlon, the fact that free speech leads to the full exercise of individual autonomy, Alexander Michael John, who said that in a democracy you cannot not have free speech because democratic governments cannot work without accountability, and speech is what ensures that. So when we were articulating the demand for a right to free speech as part of the Indian national movement, we relied on these universal bases. But when it came to formulating the right in the Constituent Assembly, we actually based our concerns around the particularistic context of India, which was partition primarily, but a lot of other things also, which is how the idea of reasonable, which was not called reasonable at that point in time, it was the 1951, the first amendment to the Constitution that added the word reasonable, but the idea of restrictions very much was present in the Constituent Assembly, and this idea of restriction was based on particularistic considerations. So what is the argument? The argument is this. The constituent makers said that free speech is a universal value, but we can't have it as an absolute right because we are faced with particular concerns. And in order to respond to those particular concerns, we need to limit the right. And the limitation to right emerged in form of the restrictions. So in the name of, and I'm not going back to the history of reasonable restrictions because it has also evolved. Clauses have been added over time. So I'm relying on what we have now as by way of reasonable restrictions. So we have the public order clause, we have the security of state clause, decency, morality, contempt of court, a range of these clauses in the name of which your right to speech and expression can be limited. What does it translate into? It translates into a judicial exercise wherein if you claim that your right to freedom of speech has been violated and you approach a court saying that your right has been violated, the court is going to decide, and there's a case against you, the court is going to decide whether your expression is detrimental to one of these clauses in the reasonable restriction section or not. So is your speech detrimental to public order? Is your speech against the morality and decency in the society? Is your speech detrimental to the security of state? So on and so forth. And if it is, your expression is not to be granted to you as a right, and the law is, and the executive is right in restricting your right to freedom of speech and expression. So that's the idea of harm that emerges. What I'm going to do is look at how harm has been conceptualized first in Indian law. So largely the Indian Penal Code, which gives you the offenses in the society, and then see whether we get a theory of harm from Indian law perspective or not. So let's look at what are our speech offenses. By way of political speech, we have sedition, which is not a protected form of speech. So if you commit sedition, I mean, the law is in a state of limbo right now because it's been suspended, the section, that's a different matter. But it still very much exists as an offense on the statute. So if your speech is said to be seditious, you can't claim it as your right. So if you say things that are interpreted to be inciting disaffection against the government, you can't claim it as your right. So there are offenses that criminalize political speech. Then there are offenses that criminalize communal speech. So section 295A, section 153A. What is the language that they import? Section 295A, which was recently in news a lot because of the Nupur Sharma case, talks in the language of insult to religion. Section 153A talks in the language of spreading communal disharmony. Then there are offenses related to obscenity, section 292 IPC, which talks about anything that is considered to be obscene cannot be granted, propagation of that particular thing which is considered to be obscene can't be granted to you as part of your right. How is obscenity defined? It is defined as something that ignites prurient interest or something that depraves or corrupts the morality of the society. Now, if we put all of these things together and we ask a simple question, of course I'm working with oversimplification of all of these technical legal categories, but in the larger interest of clarity I'm doing that. If we try and club all of these together, and ask a simple question, who is the law trying to protect? What is the answer that we get? So in trying to say that you don't have a right to commit sedition, you don't have a right to propagate hate speech, you don't have a right to express things that are considered to be obscene, who is the law trying to protect? One of the ways of looking at it could be that the law is trying to protect the targets of these expressions. So if it's pornography, the law is trying to protect the women who can be the subjects of porn. If it is hate speech, the law is trying to protect the community, the vulnerable community which is at the target of hate speech. If it's sedition, the law is trying to protect the government. But is the law really doing that? Is that the conception of harm that we get from the language of law? Actually not, because if you look at the language of these sections, what is it that they import by way of language? Insult to religion, corrupting the morality of the society, depraving the morality of the society, public order, so on and so forth. So what we have by way of a free speech discourse emerging from the Indian law is an overwhelming understanding of the public order conception. So I'll take an example of hate speech. So hate speech, the Indian law does not have a definition of hate speech. What it has is two particular sections that are popularly termed as hate speech. One that talks of insult to religion and the other that talks about promoting communal disharmony. Now, in both of these, commonsensically, if our understanding of hate speech is a speech directed at a particular community, the concern of law should be to protect that community. But the language of law is not talking about protecting a particular community. The law is talking in the language of protecting public order. So insult to religion will result in public order, public disorder, which is why insult to religion cannot be granted to you as a right. Or if you say something that spreads communal disharmony in the society, which then again is linked to public disorder, it can't be granted to you as a right. So in terms of the conception of harm in Indian law, what we have is not a target-driven understanding. So free speech is not something that is restricted to protect certain vulnerable targets. It is restricted to protect either of these things, which is either public order in the society, security of state, decency of the society, morality of the society, etc., etc., etc. So individuals who can be targets of certain kinds of expressions is not what the law is concerned with to begin with. Has the judiciary changed this understanding? Yes and no, and which is what we get to next. The jurisprudence on free speech in India, and probably 15 minutes is too less to talk about it. So very briefly, I'm going to give you certain landmarks, judicial landmarks, which help us, if there was a board here, I would draw a pattern. It helps us draw a pattern in terms of where are we placed. This is an argument that Lawrence Liang has made, that if you look at the American jurisprudence on free speech, the pattern is linear in nature. So it moves from one direction to the other in a linear fashion. It starts from A point and reaches B point progressively. What is a linear pattern? That there was a judgment given which was subsequently either upheld or modified by another judgment, so on and so forth. It's the rule of the precedent. How does the American jurisprudence work in this linear manner? So America, until the early 20th century, this was the time of the First World War. Towards the end of the First World War, America worked with the idea of something called the bad tendency test. What was a bad tendency test? Any speech which had a tendency to result in anything harmful was to be restricted and was not to be permitted. Now, bad tendency test did not have any caveats attached to it. So there was no way in which you would be able to define bad tendency. So anything, even an abuse, could be interpreted to have a bad tendency. So bad tendency had a very wide ambit. Any kind of non-pleasant expressions could be clubbed under the bad tendency. In 1919, the very celebrated American judge, Justice Holmes, revised this understanding of restriction on free speech by proposing another concept, which was the clear and present danger test. And he used an analogy to propose it. The analogy was a situation like this. Say a theater. Now, if you raise a false cry of fire in a theater, it poses a clear and present danger in that particular situation. Why? Because it's a theater, it's a confined space. If you cry out fire, fire falsely, it's likely to result in a public order situation. Because there is no other way in which you expect people to react in a confined space. So Justice Holmes said that the bad tendency test would probably penalize false cry of fire in an open space as well. But in an open space, even if it's a false cry of fire, why do you need to penalize it? As a democracy, we have to be mature enough to tolerate certain kinds of expressions that may be untrue, unpleasant, but are not likely to result in an immediate danger. But clear and present danger test was to cater to only those kinds of expressions that immediately pose a certain danger, and in which the danger, which is the consequence, is very, very proximately connected with the expression. The danger is likely to follow. Now, this clear and present danger test was subsequently revised in 1969 by another test called imminent lawless action, in which three kinds of criteria were identified. This is all US Supreme Court. It devised a three-step formula. The first was that if there is say a speech which advocates violence, the first thing that the judge should look for in adjudicating that particular case is the incitement to violence of an express nature, explicit nature. So if I'm trying to say something between the lines, when I'm not expressing anything explicitly clearly, then I'm not to be penalized for it. Second, in that explicit call for violence, is there an immediacy to the call? So if I am inciting violence, am I inciting you to commit violence immediately, or I'm saying 10 years down the line you should be able to do things? If there's no immediacy to my call of violence, even then my call of violence should be protected. Why? Because if I'm giving you a 10-year timeline, then the liberal idea of freedom of speech would say that people have enough time to think. They're not acting under the pressure of the speech. If they still decide to act on the speech, it's their responsibility, not the speaker's. And the third, that even if there is explicit incitement, there's immediacy to it, is the situation likely to occur? So if I'm inciting you to violence, are you likely to commit violence on my incitement or not? That's the American standard. Where are we placed by way of a free speech jurisprudence in India? Like I said, the American standard moves in a linear fashion. In India, we move in a crisscross pattern. There is a judgment which devises a test. The judgment that follows after does not follow the precedent, devises another test. And what we have is offense-specific test. So in case of a hate speech, there would be a different standard. In case of sedition, there would be a different standard. In case of obscenity, there would be a different standard, so on and so forth. I'll take two examples and then move to the linguistic part. There are two cases that I'm going to talk about. The first case, which was decided in the 1950s, it was a case called Ramjilal Modi. And the second case, which was decided in 1989, it was the Rangarajan case. The names are not important. The criteria that they involved did. So in the 1952, in the case called Ramjilal Modi, the Supreme Court said that, and it was a case in which Section 295A, which is insult to religion, was challenged. The petitioner said that the section is unconstitutional because insult to religion does not necessarily result in public disorder. My religion may be insulted by someone, but that does not mean that I'm going to create a public order situation necessarily. And the Supreme Court said in that particular case that the Indian Constitution works with the phrase "in the interest of public order." Now, in the interest of public order, even if there is a situation in which your expression is not directly causing a public disorder situation, the interest of public order causes for restriction on your expression to be imposed. So, even though insult to religion is not directly linked with public order, it might be a situation that insult to religion can result in public order. Now again, going back to the fact that it's a hate speech case and the concern of law should be to protect the vulnerable target, how is the law addressing it? It's addressing it by way of not looking at the target of the hate speech, but looking at what would be the response of a propagation of hate speech in the society. So what we have in India is something called the heckler's veto. So if I heckle too much, then the society is going to respond to my call for heckle and not allow the other person to be at the receiving end of my target. If I have to take examples of heckler's veto, these organizations that protest against a film to be released. Why is the film either not allowed to be released or the name is changed, etc.? Because the Indian law is responding to the call from the heckler's veto. Because people are heckling against a particular expression, the law takes the course of not responding to the heckler by way of crushing the heckle, but by making the receiving end of the target tweak his or her stance. So this was Ramji Lal Modi. I am coming to 1989. In between, a lot of things happened which I wouldn't have the time to go into, but the criss-cross pattern continues over time. There is no set rule of precedent that the judiciary seems to be following in cases of hate speech. But the 1989 case is very, very important. It's the Rangarajan case, in which the Supreme Court evolved a phrase called spark in the powder keg. Do you all understand what a powder keg is? A gunpowder barrel. So if there is a spark near a gunpowder barrel, what is the most likely consequence? Explosion. Now, a spark is a spark. But if the spark takes place in a space where there is nothing to be exploded, the spark has no effect. But if the spark takes place inside a gunpowder barrel or near a gunpowder barrel, the same spark is likely to create an explosion. Now, how did the Rangarajan case evolve this as a free speech test? It said, it's not the content that matters so much. So spark will remain the spark. You can say the same thing in a different context in which the speech will not have any effect. But if you say the same thing in a context that is inflammable, which is volatile already, your speech is going to result in public disorder. And the Supreme Court, through this particular phrase, spark in the powder keg, evolved a free speech test, saying that it's the context of the speech that matters. If the context is volatile, the speech should be restricted. Otherwise, the speech should be tolerated, even if it's unpleasant, etc. in nature. Now, this is where the judicial stand is. And in Shreya Singhal, in which Justice Chalameshwar was also on the bench, the American standard was adopted and the spark in the powder test was further congealed. Where Shreya Singhal, in declaring 66A of the IT Act unconstitutional, made a distinction between advocacy and incitement. And Shreya Singhal judgment said that advocacy of violence needs to be tolerated. Because if I'm advocating something, I'm just opinionating. It's my opinion. I am advocating something. So advocacy of violence should be tolerated, but incitement to violence cannot be tolerated. Because when I'm inciting you to do something, I'm not just opinionating. I'm urging you to commit a particular act. Where are we left after going over the trajectory of judicial review? What we have is these words: powder keg, incitement, tendency, so on and so forth. So what the judiciary seems to have done is evolved these larger phrases or the free speech tests to be followed without getting into the nitty-gritties of how are these tests to be implemented on the ground. Which is where I turn to linguistics and offer this, propose this particular argument, that a linguistic analysis of speech can be very, very helpful to jurisprudence in devising how can these free speech tests be implemented. And I'll work with just one particular example, spark in a powder keg. But before that, let's try and understand what a linguistic analysis of speech entails. Like I said, I'm drawing from J.L. Austin's work, How to Do Things with Words. J.L. Austin makes an argument in which he says that all kinds of expressions are actions in narrow senses or wide. So when I say something, I'm not just saying something, I'm also committing an action. There are two ways in which speech can result into action. Number one, either the speech itself is an action, and number two, the speech can result in an action. So either the speech itself is constituting action or the speech will cause an action in terms of consequences. The former category of speech he termed as illocutionary, and the second he termed as perlocutionary. Examples of illocutionary: thank you. So when I say thank you, I don't need to do anything extra to thank you. I've already thanked you in the act of saying thank you. Similarly, when I say I promise, I don't have to do anything extra to promise. I have already promised whatever I had to in saying I promise. The declaration I do, which means marriage has already been solemnized in the act of saying, in the utterance I do. There doesn't need to be anything extra that need to be said in order for the act of marriage to be performed. Now, these are elocutionary set of expressions that constitute action in themselves. And then there are other kinds of expressions in which when I'm saying something, I'm not necessarily doing an action, but my saying will certainly result in an action, which includes all other kinds of expressions. Everything that we say has a consequence. Now, how is this theory helpful? It's helpful in one simple manner. When I say that my speech is either constituting violence or resulting in violence, how am I drawing this particular inference? So when the judiciary says that this particular utterance cannot be permitted under right to freedom of speech and expression because this utterance has the likelihood of resulting in violence in the society. On what basis is the judiciary saying this? Spark in the powder keg, tendency to result in violence, etc. are judicial formulae to rely upon. But how can these judicial doctrines be understood better using the idea of elocutionary speech acts? Now, J.L. Austin says that not every kind of speech can have an elocutionary effect. What is an elocutionary effect? That the speech will result in an action in the act of performing the speech itself. Let's take the example of I do. So when I say I do and I expect the ceremony of marriage to be solemnized, there has to be a proper context to it. The two people who are performing the utterance of I do should also intend to marry. They should be rightly, appropriately placed in a context in which marriage is likely to happen. It should be a context which provides for the conventional act of marriage to be performed, etc., etc. Similarly, when a gavel is banged, which judges do in order to bring about order in a courtroom, is banging a gavel by someone who's not a judge in a situation which is not a courtroom likely to have the same effect that it would have in a courtroom by a judge? No. So, for elocutionary acts to be performed, there has to be a total, what Austin says, total speech situation. What matters here is the authority of the speaker, the nature of the audience, the intention of the speaker to convey something, the mental faculty of the audience to be able to understand the intention of the author, all of these things, appropriate context. All of these things form what is called an enabling context. If a speech has to be efficacious, it has to be effective, all of these conditions need to be met with. If the author does not have the authority, even if the author is inciting violence, the incitement is not going to result into violence necessarily. So what the performative utterances and elocutionary acts is what he terms as performative utterances. These are utterances that are not just spoken, but they are also performed. There are acts performed in the uttering of these utterances. Sorry, I mean, that's tautology, but now, if we were to apply this speech act theory, the idea of the elocutionary and the perlocutionary, to the domain of speech, while adjudicating it, what do we have? We have further qualifications to reconsider the judicial doctrines. So if we look at the idea of spark in the powder keg, how is this context of the powder keg to be read now? So what will form a powder keg? If I say something inciting here, is this room, is this theater a powder keg? How will I interpret whether this is a powder keg situation or not? By looking into all of these criteria that Austin says provide for a total speech situation. Are you under a certain kind of persuasive effect? If I'm going to say something, are you likely to act on it? Do you understand my intention exactly in the same manner in which I want to convey it? All of these things would matter. So linguistics, and I've taken just one example, can help address this question that the judicial opinion is constantly confronted with. When is a speech likely to cause a threat to public order? This understanding or linguistic analysis of speech can be helpful there. But having said that, and I arrive at my third question, can the same legal standard be applied across all kinds of speech crimes? Having said that, the next thing that I propose is this, that this idea of the linguistics trying to help the jurisprudence can work only when we are dealing with offenses that have a public order conception. So offenses in which the harmful quotient of that is being judged on the basis of whether certain harm is posed to public order and security of state, etc. or not. Where it won't work is the other kinds of offenses in which the speech is not likely to result in a spark, but the speech is likely to have a silencing effect on the target. And which is where the Indian law is largely silent. One of the examples where the Indian law actually addresses this aspect of harm in free speech is the POA, Prevention of Atrocities Against Scheduled Caste and Scheduled Tribes Act. When they say that one of the offenses under the POA Act is hurling casteist abuses. So why is this idea of a caste abuse a separate category of offense altogether? Because of the detrimental effect that it is likely to have on the target of that particular abuse. But besides the POA, the Indian law largely does not work with a target-driven understanding of these offenses, which is where I say that what we need to get into is a disaggregated standard of judging different offenses. There are expressions that incite, and there are offenses that don't necessarily incite the audience. In fact, they corner the audience into silence. So when I'm inciting violence, quote unquote, against a particular community, I'm addressing two kinds of audience. First, people who are likely to act on my incitement against that particular community. Second, the community itself. The community which is at the receiving end of, say, stereotypes about that community. The Indian law so far addresses, under the name of freedom of speech and expression, the former, which is that community which is likely to act on the incitement against a particular community, which is public order. It does not so much focus on the second kind of audience, which is likely to bear the burden of that expression. Again, an American philosopher, Jeremy Waldron, who's worked on racial speech in America, has introduced a very, very inventive idea of, or inventive conception of harm in judging offenses which are social in nature, which address social kind of speech, like racial speech, like hate speech, like communal speech. He introduces the idea of environmental harm. How is environmental harm different from other kinds of physical harm? So, physical harm is something that you are to experience on an immediate basis. It's something that will happen to you immediately. Environmental harm is not something that's likely to have an immediate effect, like pollution. The impact of pollution is going to be felt by you years after years. If we are to look at hate speech from the lens of environmental harm, the response to hate speech will have to change. So when we are addressing hate speech, what we need to look at is not whether hate speech is likely to result in a public order situation or not, But we need to look at whether incrementally hate speech is going to result in degenerating a particular community which is the consistent recipient of that hate speech or not. So if you employ the idea of environmental harm, which is going to work progressively, incrementally towards a certain end, the response of Indian law would change, which is not to look at these kinds of expressions like hate speech or say pornography, which produce a certain kind of stereotype about women. Then the response of Indian law will have to be different from the public order preoccupation. Freedom of speech and expression does not need to be limited necessarily on the public order ground. For that, we have certain volatile contexts that need to be defined. But when it comes to other reasons for which certain kind of expressions need to be limited, addressed, what we need to look at is the long-term effect of that particular speech on the target community. If we start to do that, what we would arrive at, and please let me know if this conception works, is not to look at the question of free speech as a liberal project, to liberate the question of liberal speech from, the question of free speech from the liberal project and place it in the equality project. If we start looking at the question of freedom of speech and expression from this angle, from the point of view of the target, the addressee, and the silencing effect it can have on the addressee, that's the time when we'll begin to look at even the right to freedom of speech and expression, not just as a liberal question, but as an egalitarian question, as an equality question. There are scholars that have already propounded the way forward. Martha Nussbaum and Amartya Sen's capability approach, which most of us are familiar with. That particular approach can also be employed to understand what right to freedom of speech of expression can mean. Right to freedom of speech and expression so far in Indian law means I should have the right to say whatever I want to, provided I do not create an obstacle for the reasonable restrictions to be implemented. But it's basically my right to speak. What the capabilities approach how it helps us tweak is in this manner. That right to freedom of speech and expression can't just be about my freedom to speak. It should also be about creating a civil society culture in which my right to expression is equally valued as the other person's right to speech and expression. For that, what you need is a certain kind of equal footing in the society for every kind of expression to be respected and valued equally. How is the capabilities approach helpful here? If there is a privileging of the expression of certain kinds of people and a devaluing of the expression of certain kinds of people, I'm just winding up. And a devaluing of the expressions of certain other classes of people, the capabilities approach calls for a positive action on part of the state to build the capabilities of those people whose expressions are devalued, so that they are able to produce what is called a counter speech. So if I say something that is unpleasant to you, that devalues you, you should be able to talk back to me on an equal footing. Now this kind of speech culture will make speech regulations redundant. You won't need law to regulate this. What you will have is an organic culture of expression in the society in which talking back or counter speech on an equal footing would take care of the contentions that different kinds of expressions entail. That's all. Thank you.
Thank you very much, Dr. Anushka. I was getting up just to suggest that, not to curtail free speech, just to suggest that because there'll be an interactive session, you would have, we'll have more time also to discuss.